analysis for 5th of February 2024. Now, let us start with the today's agenda of the day, where we'll be discussing some interesting editorial which is related to the 4 issues of the Honorable CJI DY Chandrachud, which highlighted within the legal profession. So, what are the 4 major issues that are there in the legal profession which are being highlighted by the present CJI, Honorable Justice DY Chandrachud? Now, next we'll be discussing some interesting news update, and next we'll be discussing some legal news update of the day. Now, the editorial section which speaks about the 4 issues which are there in the legal profession. Now, delivering this in the Foundation Day, which addressed on the Supreme Court's 75th year of establishment on January 28th, and the CJI highlighted 4 issues within the judiciary that will have to be addressed through difficult conversations. This were adjournment culture among lawyers, the first one. The second one, limiting the length of oral arguments. The next, the length of court vacations and providing a level playing field of first generation lawyers from diverse background. Now, what is the state of thing on these 4 courts and how have been they addressed in the past? So let us discuss issue-wise. So the first is the adjournment culture and its effect on justice delivery system. Now, in a 2016 judgment, which is Gayatri versus M. Garish, Justice Deepak Mishra detailed a lawyer's endeavor to master the art of adjournment, as he had successfully gotten a case adjourned 15 times at the trial court. He described the effect on the case, stating the proceeding in the suit got arrested as if time had been arrested. The adjournment, which has been referred under Order 17 of CPC, provides rules for court to follow when faced with adjournment request. Among the other rules, it states that court shall not grant an adjournment to a party more than 3 times during the hearing of the suit. That sufficient cause must be shown, and then circumstances should be beyond the reasonable doubt and beyond the control of the party. While adjournments are often necessary, the delay cause has a cascading effect of increasing the number of pending cases. Now, there was a Law Commission report on the same, which was 239, and which was the year of 2012, which listed the cause of delay in criminal cases at the trial stage. Now, the Law Commission of report stated the heavy workload in the courts is taken advantage of by advocates to press for adjournments. So it's a vicious cycle where adjournments led to heavier workload, which led to even more adjournments. Last November, Honorable Justice CJI Chandrachud, quoting a famous Sunny Deol dialogue, cautioned the lawyer against turning the Supreme Court into Tariq pe Tariq court, where adjournments are frequent. He disclosed that the preceding 2 months have seen 3,000 plus adjournment requests despite repeated calls from lawyer for matters to be listed expeditiously. So this was the first issue which Honorable CJI Justice talked about. Now, the second issue that we are discussing here is keeping length of oral arguments in check. So often in the constitutional bench matter, the court will direct the parties to confer and create a time schedule for oral agreements. This is to ensure efficiency and so that the arguments are not repeated by the lawyers on the same side. Now, the practice can be tracked back to the Ayodhya title dispute. In January 2019, Honorable CJI Ranjan Gogoi, third and CJI, directed the parties to draw up a time schedule for hearing due to the vast number of parties and lawyers. Now, however, the case was heard over 60 times from August to October 2019. The court has had better luck with this method in the recent past. Now, after the Constitution Bench brought during CJI NV Ramana tenure, 25 Constitution Bench cases were listed right before CJI UU Lalit took serene in August 2022. Another opinion is adopting an approach similar to Supreme Court of the United States, where lawyers are instructed to strictly limit their arguments 30 minutes aside. This was considered in the 19th Law Commission report. However, The majority of people whose opinion was sought were grant against opposed the strictly limit. Now, the next one is the CJI referred to the possibility of alternatives like flexi time for lawyers and judges. This is a practice where employees are allowed to choose their daily working hours. They work for a set total number of hours in the given period. Now, the similar arrangement was introduced in 2022 for employees and judges working at the Metropolitan Regional Trial Courts in Philippines. In the past, the Parliamentary Standing Committee on the Personal Grievance Law Justice, headed by BJP MP Brijlal, suggested in its 133rd report that High Court judges take turn going on vacation to tackle the mounting tendency of cases. The central government has also brought up the issue of the court vacations earlier. In 2022, the then Law Minister Kiran Rijiju criticized the judiciary for taking long vacations even as pending cases hit record level every year. Now, the last time the Supreme Court took action on vacation was in 2014. The court notified that new Supreme Court rules which state that the summer vacation shall not exceed 7 weeks, reduced from 10 weeks. This was in line with the suggestion of Malimat Committee report of 2003. Now, the last issue was level playing field for first generation lawyers. CJI Chandrachud also stressed the need to provide a level playing field for first generation lawyers and those from marginally segment who have the will to work and potential to succeed. Highlighting recent progress, he said that 36.3% judges in the district court and over 50% of the candidates selected in the recruitment exam for junior civil judge are women. 41% of law clerk candidates Supreme Court are also women. Now, the Supreme Court annual report took note of the Supreme Court Advocate on Record Association efforts to facilitate more diversity in legal profession. Now, this include providing better facilities for women lawyer, giving more weightage to first generation lawyer when designating senior advocate and allowing lawyer to appeal via video conferencing on all working day so that first generation lawyers and women lawyers with young children can appear with few obstacles. Last year, Justice Hema Kohli also noted that entry of first generation lawyers from different backgrounds and the increased representation of women in legal profession are step towards inclusivity. 5 months later, bench dismissed a challenge to practice of designated senior advocate. It said that the number of first generation lawyers have grown over time and that it is contemptuous to allege that lawyers only become known for their wealth and the proximity to the bench. So I think they were the very crucial issues that Honorable CJI Justice DY Chandrachud have dealt here, and we should ponder upon these issues. And at the bar and the bench should have that balancing so that both can work for each other. So that's all for the editorial section. Now we'll be discussing some interesting national news. UPI gets global launch at Eiffel Tower in France. India has formally launched UPI at the iconic Eiffel Tower here, forming it as taking Prime Minister Narendra Modi vision of taking UPI global. Now, UPI means Unified Payment Interference was launched in 2016. It's a system that powers multiple bank accounts into a single mobile application, merging several bank features, seamless fund routing, and merchant payment into one hood, according to NPCI. Now, Emmanuel Macron, the president of France, was the chief justice of the 75th Republic Day celebrations in New Delhi. Now, Eiffel Tower is the first merchant to offer UPI payment in France, and the service will soon be extended to other merchants in the tourism and retail space across France and Europe. So it's a very good news coming up for us. Now, India beat Nepal by 132 runs to enter semi-final of ICC Under 19 Men's World Cup Cricket. So, India stormed into the semi-final, defeating Nepal by 132 runs at the Mangong Oval in Bloemfontein, South Africa last night. Now, chasing 298 victory, Nepal scored only 165 runs with loss of 9 wickets in 50 hours. India will now face host South Africa in the semi-finals at Benoni on Tuesday. Now, let's see and we'll keep you updated. Abhinav Bindra selected as a torchbearer for Paris 2024 Olympics. So, former shooter Mr. Abhinav Bindra, India's first Olympic gold medalist, will take part in the Paris 2024 Olympic torch relay. The Olympic torch relay is an ancient tradition that precedes the Summer Games. The modern iteration of the relay has been in practice since Berlin, which is in 1936. Abhinav Bindra, also a member of Athletics Commission of the International Olympic Committee, was selected through an elaborate process which started on June 1st last year. Exercise Vayu Shakti 2024. Indian Air Force will be conducting Exercise Vayu Shakti 24 on 17th of Feb 2024 at the Pokhran Air to ground range near Jaisalmer. This year, the exercise will see participation by 121 aircrafts, including the indigenous Tejas, Prachand, and Dhruv. Special operations by the Indian Air Force, transport and helicopter fleets involving the guards and the Indian Army elements will also be on display. US approved sale of 31 Predator drones to India. So the US has approved the sale of 31 MQ-9B armed drones to India at an estimated cost of US $3.99 billion, an American Defense Agency announced here. The proposed mega drone deal was announced during the historic state visit of Prime Minister Narendra Modi here in June 2023. Now, under the deal, India will get 31 high-altitude long-endurance UAVs, of which the Navy will get 15 Sea Guardian drones, while the Army and the Indian Air Force will get 8 each of the land version Sky Guardian. Maha Gaurav 2024 award presented to Nikhil Wagh by Maharashtra Deputy CM Ajit Pawar. Nikhil Mukund Wagh, who works as a public relation officer at Goa Shipyard Limited, was recently given the Maha Gaurav 2024 award. This award has handed to him by Shri Ajit Pawar, the Deputy Chief Minister of Maharashtra. The award is a big deal because it recognizes Nikhil's great work in public relations. L.K. Advani to be honored with Bharat Ratna, India's highest civilian award. The government on Saturday announced honoring senior BJP leader and the man behind the Ram Janmabhoomi movement, Lal Krishna Advani, with Bharat Ratna. He will be the 50th recipient of the highest civilian award since its inception and the 7th during the Modi government regime. It was the Advani as BJP chief when the party adopted the Mandir pledge in 1989. And then this Rath Yatra in 1990 from Somnath in Gujarat to Ayodhya in UP to build the Ram temple changed the course of Indian politics. Now, he is born in Karachi in present-day Pakistan on November 8, 1927. Advani, through years, had served as the president of Bharatiya Janata Party for the longest period since its inception in 1918. BHU, that is Banaras Hindu University, launched Human DNA Bank under Make in India initiative. So BHU has initiated 2 groundbreaking endeavors: the establishment of the Human DNA Bank and the imminent completion of the Wildlife DNA Bank. This initiative, powered by cutting-edge technology such as automated DNA extractor machine, epitomizes India's commitment to innovation and indigenous manufacturing under the Make in India initiative. Now, coming up to the legal update of the day from the Supreme Court. Supreme Court in the recent judgment observed that if a plain reading of a clause fulfills the object and the purpose of the statute, then the rule of reading down the clause would not be applied just because the clause imposes harsher consequences. Now, the court has said that the rule of reading down the provision should not be applied at the first instance, but should always be the last resort, only when the court finds that a particular provision, if for its plain meaning, cannot be saved from invalidation. So the case name is Authorized Officer, Central Bank of India versus Shan Mugavelu. Now, the next coming from the Allahabad High Court Arbitration Act Debatable questions of fact cannot be decided in proceeding under Section 11, subclause 6. So the Allahabad High Court has reiterated the principle that the scope of judicial review in the proceeding under 11, subclause 6 of the Arbitration Act is very narrow. The court held that debatable questions of fact cannot be gone into by the court while adjudicating an application for appointment of arbitrator. The scope of judicial review in deciding issue of arbitrability is very limited. And the case name is Mrs. Neelkant Construction versus Union of India and others. Now, if you want to revise your previous TNA, do attempt the quiz link that is mentioned in the description of this particular video. If you like the video, do share with your friends. Do subscribe our channel for, getting the regular updates. Thank you so much for watching. Do take good care of yourself.